Hello. The Divine Code reading for April 18th, pages 631 and 632. We are in the chapter Laws of Saving Oneself or One's Property at the Expense of Another's Money and Taking the Law into One's Own Hands. Topic number 13. If some type of damage is coming upon a person's property, for example, a river is flooding his land, he is not allowed to divert the coming damage from his property if doing so will cause it to occur to another person's property. Since one cannot save oneself if the result will be a cause for damage to someone else. So we're not talking about the risk of life and limb. We're talking about the loss of property. You know, the person's house is going to get flooded, and is he allowed to put sandbags around his house in order to protect his house? But that sandbags around his house is going to cause his neighbor's house to flood. Before the damage actually occurs, though, it is permissible to prevent it by befalling his property if his action will cause damage, even if this action will cause damage to another. That is, if the river is flooding its banks, if the river eventually floods its banks, and it will soon be overflowing into his field. If it has not yet reached his field, he may build a blockade. Even if so, by doing so, he causes it to flood a neighbor's field. Once it has already begun to damage his field, however, he may not do so, as this is removing damage from oneself onto another. And that's Rema Koshan Mishpat 388-2 and Sefer Mirid Eliam there, Part 10, Shokanor Korav, Laws of Monetary Damage, topic number 2. Now, this is also just like just about everything in this particular chapter. It's not clear halakha. This is areas of applied applications that are given in difficult situations, various situations that are determined by local. This would be the purview of a local government. The nation, the individual nation decides how they're going to handle these kind of situations, and this is how Israel has decided they're going to handle this situation of the issue of the flooded the field that is flooding. What to do if somebody finds their, in yesterday's reading, what to do if somebody finds something belongs to them. Should he just take it home with them, even if he's taking it from somebody else, perhaps somebody who didn't realize and purchased the item. Can a person simply take it himself? These kind of things are procedural concerns that my suggestion is that they would be determined by the local government. And these are not set in stone, so to speak. So how a government would decide that they're going to handle things like watershed issues. In the United States, we have the Army Corps of Engineers that does tests, and anytime, and they determine how to handle rivers and how to handle flooding concerns. The state and local governments would determine if somebody wants to develop their land. So we're talking about somebody who owns a field. He's in a floodplain. Can he, on his own, decide? Let's say in the summertime, when there's no flooding, and the river's in its regular summertime banks. Can the owner of a field decide on his own that he's going to build a levee around his field to protect it? That's going to cause additional flooding to his neighbors, but not till the springtime when the floods are occurring. Can a person decide to do that on his own, or would he need to go through a process Perhaps he would need, in the United States, he might be required, if he's going to do this, he might be required to build a retaining pond that'll hold the water that would normally go on his property. He's going to take a part of his property, dig a deep retaining area, and the water that is sort of his responsibility when flood time comes, he can say, okay, I'm going to have all that water in the retaining area, and it'll be put into the river in a slower manner when the river can handle it without flooding his neighbor. That way he's not causing any damage to his neighbor. That's one way a local government can decide to handle this issue. If this is how the rabbis have determined that it should be done in Israel, then that's of course they can decide. Each local government can decide how they're going to handle their concerns in this kind of an area. But clearly, when the flood is occurring, and if he pushes the water off his property when the flood is occurring, that clearly would directly damage, it causes direct damage to his neighbors, and that would be prohibited. How he would do it off season is something to, there's no Torah prohibition off season, but the local government can still decide how they're going to handle it. Topic number 14. If one is incurring sudden damage, one may not use another's belongings, even if he borrowed them, without the owner's consent in order to save his own belongings, even if he intends to repay any damage that would occur to the other's belongings. For example, if someone's barrel of honey broke, and he has in his house a barrel of wine borrowed from a friend, he may not pour out his friend's wine in order to save the contents of his own barrel. So he has a need, and the need is very important. Now, the honey is much more expensive than the wine. That's the assumption here. And can he? The idea of borrowing a barrel of wine is an oddity. I would suggest that, let's say he is storing the wine on behalf of his neighbor. His neighbor has a barrel of wine. He said, hey, can you store this barrel of wine? The guy's got plenty of room in his house. So he says, sure, I can store the barrel of wine. Now, all of a sudden, he needs a barrel. He needs an empty barrel. He doesn't need a barrel of wine. He needs an empty barrel. So can he pour out the barrel of wine that his neighbor entrusted to him in order to protect the honey? Now, if he asks the neighbor may say sure, no problem. Or the neighbor may not say sure. We don't know. So in the case that we don't know, he cannot take it upon himself to pour out the wine in order to create an empty barrel that can put his honey in to save his honey. That would not be a permission given to him. This applies even if his honey is more valuable than his friend's wine, because otherwise it would be absurd. You know, if he has a barrel of wine, let's say water, he has a barrel of water that's leaking, and he has a barrel of something expensive like honey that's from his neighbor, it would make no logical sense whatsoever for either person to pour out the honey to save the water. So that kind of a question really wouldn't come up. But if it's more expensive, then there is a reason why the homeowner may want to pour out his friend's wine in order to protect his honey. But that logic doesn't work in this situation. Likewise, one whose bee colony swarmed to a neighbor's property and landed on a branch of his tree. may not cut off his branch in order to return the bees. Even if he intends to repay the value of the branch, and one is not permitted to save his own money at the expense of another's without the other person's consent, as doing so is considered theft. So apparently in historic beekeeping, I mean, today we keep bees in little boxes, and the assumption is the queen bee is not going to swarm away. The queen bee did swarm away. I'm not sure what the law is there, but in this understanding, the bees would be okay. Halachically, the understanding here is the queen bee, the hive belongs to the beekeeper. So if it left, he can go and retrieve it the same way you can retrieve other livestock. And can he retrieve the livestock? In this case, it's attached itself to the branch of his neighbor's tree, and he would not be allowed to cut the branch of the neighbor's tree in order to retrieve his livestock. He would have to ask the neighbor. And yeah, so the bees are understood to be his property, and the neighbor, you cannot retrieve it from the neighbor by damaging the neighbor's property. See Shokanor Karav Mish Shokanor Koshan Mishpat 264.8 and Rima Koshan Mishpat 308.7 and Shokanor Karav Laws of Borrowing Topic 6. That there is an argument between Rosh, Bava Kama 114, and Rambam, Laws of Robbery 6:14, as to whether a person can destroy another person's cheap item to save his own expensive items, with the intention to reimburse the owner for the damage. The argument hinges on whether this is one of the stipulations made by Joshua when he divided the land of Israel among the Jews. It follows, therefore, that otherwise it is considered theft. So there is an argument as to whether or not within the land of Israel it might be permitted, because the Jewish people in the land of Israel, they have a certain commonality of ownership of the land, and the way it's divided up is people have stewardship over their area, but there's still a commonality between the owners, a family connection between the owners, and therefore when they divided up the land, the understanding was they'd be able to help out each other. So that tree, even though it doesn't belong to the specific owner, it belongs to the extended family, and the extended family would allow that. But in other nations, which are not, the land is not divided up in the same manner, then it would not be a Torah allowance. Now, nations could make any rules that they want in this regard. So nations could decide that they're going to have a certain mutual benefit to each other, such as the person who has the flooded field. He can't just decide to build a levee in the summertime to protect the flooding the next year if that's going to cause his neighbors. That's up to the nation to decide how they're handling those kind of situations. But in the land of Israel, there's a possibility that there's a commonality of, there's a social contract that people might be allowed to go into the neighbor's field and retrieve their bees by cutting the branch of the. There's a possibility, and that's what the argument is about. But that argument does not apply directly to other nations unless the nation decides that's how they want to do it. It follows, therefore, that otherwise this is considered theft, since it was never permitted for Gentiles. And that, it's up to the nations to decide who owns property. I mean, that a major part of this is that Nations decide property issues. And once the nation decides who owns what the property rules are for that nation, then the laws of theft apply from that. There's no inherent ownership of land. The ownership of land is it's by edict of the crown who owns land. The government decides who owns land. The government decides what the rules are concerning commerce and property, personal property and such. The government makes these rules, and then within these rules, the prohibition of theft operates. But the issues of ownership is based on the local governments, how they decide they're going to handle it. It is arguable whether they can make such an enactment on their own. So there's some rabbis that would argue that there's people that would argue no, property ownership is property ownership, and it's just somehow inherent that there's this concept of called property ownership. How that works in reality, I can't imagine. Other than the same nations that print our money, can also decide how the money is divided up, how the money is handled. However, it is clear that without such an enactment, it is forbidden for Gentiles. So the default would be it's forbidden. It would be forbidden for a Gentile to go into his neighbor's field and cut a branch off that the bees have landed on in order to retrieve his bees. That would be the default. Unless the government decides a social contract similar to the social contract that might exist, and it's still debatable if it might exist within Israel. The local government could decide there's a social contract that would allow the cutting of the neighbor's branch to save the bees. Topic number 15. If a belonging of another person is causing damage to one's property, and he is not able to save his property without causing damage to the other's belonging, he is permitted to save his own property, and he need not be held back by the other's damage. Later, the other person may take him to court to recover the damages incurred. Nevertheless, he is obligated to cause as little damage as possible to his neighbor's property, while saving his own. And although the strict letter of the law, he is not required to go to this effort, it is nevertheless righteous behavior to cause as little damage to the other's property as possible. And it's based on Shulchan Aruch Harav, Laws of Monetary Damage, topic 5. So well, they're going to give examples here. So if something is happening where another person's property is damaging one's own property, and you understand if it's a property, it's going from one person's land to another person's land. It's damaging the victim's land. The victim can do to the extent necessary to protect his property. And hopefully he would talk to the neighbor first and try to work it out with the neighbor. And it might be the government might have a system set up to arbitrate these concerns. The zoning boards and those kind of things, the government set these things up to arbitrate these kind of issues. Therefore, so what it explains here would be the default, assuming the government doesn't have anything set up. Therefore, if the ox of one's neighbor attacks his own ox and intends to kill it, then if it is possible for him to pull the ox off without harming it, he should do so. If it is impossible any other way, it is permissible for him to strike or even kill it, so it will not kill his own ox. And see Shokanor Kosha Mishpat, Chapter 383, and Shokanor Korav, Laws of Monetary Damage, Topic 5. So the neighbor's dog is in the hen house, and he's attacking the chickens. It's possible to do whatever is necessary, preferably the least amount necessary, to get the dog away from the chickens, to protect the chickens, or any similar damage is occurring in that regard. Likewise, if another's birds or beasts are entering his shop or yard and are damaging his property, he should first warn the owner. So the first example is an emergency where there's nothing, it's a very extreme situation where if he doesn't do anything, serious damage is going to occur right away. This one is more of a nuisance kind of damage is occurring, but it's on a more moderate level over a long period of time. If another's birds or beasts are entering his shop or yard and are damaging his property. So the neighbor's got a goat, and the goat comes over and he eats things, and that's causing damage over a period of time. Or the neighbor's dog comes over and poops in his yard. This is a nuisance thing that occurs over a long period of time. You first try to work it out with the neighbor. Talk to the neighbor, say, hey, you got to keep your dog on a leash or something to that effect. If the owner still does not restrain them, it is permissible for him to forcibly remove them, even if it causes them damage. If he must put out too much effort to remove them without causing them injury, then legally he may even strike or kill them in order to protect his belongings. He may not, however, take them for himself, since the owner has not declared them ownerless. See Shokanork, Kosha Mishpat, Chapter 397, which forbids a Jew to kill such animals. It appears that this is only because the Jew is obligated to return a lost object to another Jew. In contrast, the Gentile is not obligated to return a lost object, and so he may kill the trespassing animal that's causing a nuisance for him after ample warning to their owner. So within the Jewish law, there's a mitzvah. It's a commandment to return lost items. That would include returning the lost goat that is in the neighbor's yard eating up stuff, or the dog that's pooping in the neighbor's yard. There's a mitzvah to return it. Therefore, you can't damage the thing there's a mitzvah to return. That's in the Jewish law. In the non-Jewish law, it's a intellectual obligation, which means that to the extent that it makes sense, you try to return lost objects. To the extent that it makes sense, you return the dog or the goat or whatever without damaging it, and certainly without trying to, you try not to kill the animal. But if that's the only way it can be handled, and the owner's already been warned, then that's how it has. What are you going to do? You try not to, but if that's the only way to get rid of the animal, then that's the only way to get rid of the animal that's damaging one's property. It's permissible to damage the animal in order to protect one's property. Similarly, if branches of one's neighbor's tree has grown over one's own yard, he may cut them off, since he is not obligated to endure damage from another person. Needless to say, if one's neighbor lit a fire outside, he can take the law into his own hands to prevent the fire from coming onto his own property. The Torah law even says that the fire occurred in the neighbor's field by no fault or desire of his own, so the would-be victim may save his own property even at the expense of the neighbor's property, since it is as if the neighbor's property itself is causing the damage. The cause would be comparable to a neighbor's ox fighting with his own ox without the neighbor's knowledge. They may remove the owner's ox. Then he may remove the neighbor's ox, even if he causes injury to the neighbor's ox by doing this. He is exempt from paying the damage. This is explained in Kosher Mishpat, chapter 383. So the first example, we're seeing an ox that's damaging the other ox. And we assume this is something the neighbor, there's no time to talk to the neighbor. You can't sit down and have a discussion with the neighbor while the ox is threatening another ox. It's an emergency situation. You got to take care of it. Then we see if it's possible to talk to the neighbor, we talk to the neighbor. But now we're going back to another situation, such as fire. If the neighbor's house is on fire, it may be necessary to protect one's own house that's right next to the neighbor's house by, even if that causes additional damage to the neighbor's house. It's permissible to prevent the fire from escaping over, because at that point the fire kind of belongs to the neighbor. The neighbor doesn't know it. He's out of town at the time, but his house is on fire, and that means his house is threatening the other person's house. So they can go in and take a tractor and push the thing over, pull it over or something to prevent the fire from spreading to the neighboring properties. Now we're going back to more of a subtle nuisance kind of a thing. Similarly, if branches of a neighbor's tree have grown over one's own yard, he may cut them off, since he is not obligated to endure damage from another person. So the neighbor's tree is, well, we're talking about branches. I'm thinking sewer lines with roots, but it's much more difficult to do anything about that unless you're going to dig a trench and rip the roots out. But in the case of branches, let's say the guy's branches they're coming across the fence, they're coming across into the other person's property, and they're causing damage to his house. Okay, so in that kind of a case, it's clear the neighbor's branches that belong to the neighbor, it's part of the neighbor's tree, it belongs to the neighbor, but it's coming across, causing damage. And needless to say, if one neighbor lit a fire outside, he can take the law into his own hands to prevent the fire from coming into his property. Torah law says that even if the fire occurred in the neighbor's field by no desire. Okay, so that's being compared with, okay, so the fire, which I've already read by accident, that's the case, that's being compared to the tree. It's coming from the neighbor's property, and it's considered to belong to the neighbor. So in the case of the tree that's causing damage, that tree clearly belongs to the neighbor, and the branch that's causing the damage clearly belongs to the neighbor. So he may cut the branches off the tree. He should do, although one should do so with the intent to pay back when. No, I'm sorry. I'll begin. He should give the cut branches to the neighbor if he doesn't provide ample warning. If he did warn his neighbor, and the alternatives offered were too much effort, then he may proceed to cut them off. When he cuts the neighbor's branches over his own property, that makes them legally ownerless, and he can acquire them for himself. So if he just goes out and he sees the damage is occurring, let's say the storm went by and suddenly the branch, a limb cracks and it's now causing damage to his property. He can cut the branches that are causing damage, throw them over the fence back to his neighbor because it belonged to his neighbor. Um, I suppose then the insurance adjusters can figure out who pays for the damage to the house, but in that case where it's done without fair warning to the owner of the tree, the branches still belong to the owner of the tree. However, if they've discussed it, they've already, let's say the branches are slowly growing. It's not a storm damage. The branches are slowly growing towards the neighbor's house, and the neighbor's concerned about damage. He's discussed it with they've had a meetings. They've discussed it, and there's nothing he can do. At that point, the person can do what makes sense to do to prevent damage from his neighbor's branches, and the branches are over his property, and the owner is given up ownership of those branches by not coming to terms, and therefore he doesn't have to return the branches at that point. Thank you.